On this week's episode of the Encrypted Economy, Dyann Heward Mills joins us. Dyann is a renowned privacy expert who was recently highlighted by the Business Insider as being among the 28 most influential lobbyists, advocates, and lawmakers influencing Europe's emerging technologies and the issues arising from those technologies. She has had an impressive career with roles at Linklaters, GE, Baker McKenzie, and others before founding her own data privacy firm. Recently tapped by the EU to advise legislatures on data ethics and privacy by design, she is a passionate and knowledgeable advocate. We talked about GDPR, the Schrems II Decision, and of course, privacy by design. The time seemed to fly by with her on the show, and I hope you enjoy it as much as I did. As always, if you like this episode, please subscribe, send a link to others, and let us know about it. Now, our episode with Dyann Heward Mills. Welcome to the Encrypted Economy, where we look at the business of regulation and security for all things encrypted, digital assets, blockchain technology, privacy, and smart contracts. Hope you'll join us while we explore these forces that are shaping the economy. All right, this is the Encrypted Economy. Today, we're really excited to have Dyann Heward Mills, who owns Heward Mills in the UK. She has an intriguing background, a lot of experience in the data protection sphere, and she is basically a privacy expert and an advocate and has a fascinating career, and we're so excited to have her on the show today. So welcome, Dyann. Thanks for joining us.
Thank you very much for the invite. I'm excited to be here.
Great. So to start off, as I alluded to, you've got a very interesting background. Heward Mills provides data protection officer support for multinational corporations doing GDPR, e-privacy regulations, cybersecurity, legal, regulatory, so the whole gambit. Dyann has 20 years of experience in data protection and cybersecurity, and the EU appointed her as an ethics expert and tasked her with advising legislators on privacy by design. Anybody who knows me, that anytime you get into something by design for software development, I get really excited. She works a lot with the C-suite level, as I said, global in scope, building robust privacy and data protection programs, works on governance, trust, transparencies. She's written a lot. She's spoken a lot. She was with Baker McKenzie, Linklaters, GE, the whole gamut. And she comes from a very intriguing, storied background. It's definitely not the crew of underachievers in your family. So, Dyann, what's it like growing up in the Heward Mills family? Tell us a little bit about yourself.
Yeah, my family originated from Ghana, and we have a lot of lawyers in the family. I think coming from a developing country, and many will relate to this, if you have the benefit of education, you've got very limited choices in terms of what you do for a career. You could be a doctor, an accountant, or a lawyer, I think, essentially. But no, we do have a number of lawyers in the family, including my mum, actually. So she's a qualified lawyer herself, practiced in the UK and also in Ghana. And I guess I grew up around the law and by osmosis absorbed it and felt very natural operating in this sphere.
Great. And when you came to the UK and you were starting off your career, starting to get at bat with Linklaters, you had 3 children, and then you also surprisingly acquired guardianship of 3 more.
So actually, at the time of acquiring guardianship, I actually had 2 children. So I went from 2 to 5 and then had my surprise. Daughter, who I love dearly. I have to always say this, you were very much wanted and very much loved, but you were a surprise.
It was just a lot.
Absolutely. At the time I was qualified as a barrister, so effectively you're self-employed. And it's something I've been scratching my head over since. I've never had maternity leave because as a self-employed practitioner, you don't have mat leave, you don't have maternity leave. What I've managed to do is to strike a really good balance between sort of work and family life. I've always had to do that, always working around the children, but continuing in my career, which has also brought me a lot of satisfaction. So I'm a very strong advocate supporting any family that wants to do the same, mothers that want to work, and those that want to obviously be home and raise children, absolutely admirable too. But I think you should just, the important thing is having the choice. And I feel very grateful that I've had that choice throughout my career.
You started off with Linklaters and you started off with binding corporate rules. That's what you were tasked with initially in a law firm. Having worked at a law firm, you think like law firms are also compliant. But one thing I learned working in a law firm is if it's not billable, they really don't want to do it.
Yeah, that is a challenge. And again, I'm very fortunate that we were able to persuade the senior practitioners at Linklaters of the importance of getting data and data management in particular. I had a very sort of visionary partner there, Christopher Millard, who also was my lecturer at university, who saw the benefits of having a global program that had been sanctioned by the supervisory authorities. And that's what binding corporate rules allows for. Interesting, still as relevant today as it was 10 years or so ago where we were making that application. Effectively, it allows for an organization to transfer data freely within the group, the corporate group, but also you have to demonstrate before you get that accreditation by the supervisory authorities, as I say, that you have got a robust program in place, that you have the right policies and procedures in place, that you've got the right an audit framework in place, that you are training your individuals within the organization, and that there's good accountability throughout the organization for data protection. Having that vision 10 years ago was fantastic. And since then, I've gone on to develop programs in-house and also advise on programs for other multinational organizations and small, medium-sized businesses too.
So when you look back at Linklaters, what was a single thing that enabled you to push this through? If you look back at it, what was the biggest obstacle and what was the thing that enabled you to get past that obstacle?
I think it's the same issues really that many privacy practitioners, data protection officers, chief privacy officers face now. It's a question of persuading. You have to persuade the decision makers because it is an investment of time, which is money in a law firm and in any other organization, and engaging valuable resources to this issue of building a privacy program. And so it's very much convincing organizations of what's in it for them. And I guess a key point to get across is what happens if we don't do this? And what happens if we don't get this right? And you don't really have to go far in a law firm to understand the importance of good information governance and compliance, because when things go wrong in terms of impact on brand, it will and can be very devastating. And really, it was interesting in terms of just the focus that data protection, privacy, compliance was getting. And it's only increased, actually, since then. It was a question of actually drawing attention to this issue and its importance and being persuasive in getting senior leaders within the organization to understand the importance and to buy into supporting investment in a data protection and privacy program.
I guess like any big organization, everybody says, yeah, sure, of course we'll do that. And then there's a question of now you have to implement and people actually have to do work. And that's where the rubber hits the road. But I was feeding you that one because I figure in your DPO, what happened at Linklaters is a petri dish for what happens in any big organization. It's always the tone at the top and convincing at the top level that, hey, compliance does matter. It can impact our reputation. It's something that we have to do. And privacy is obviously increasingly becoming more and more important, particularly as we have cybersecurity breakdowns, US no exception there. So you went on to GE Capital, then you went to Baker McKenzie, and by then you were beyond just binding corporate rules. You were getting into AML compliance, data protection audits, records management, cloud computing, regulatory approvals, data breach management. Wow, you had your shovels going and you still had all those children, which we noted earlier.
I guess that's the joy and the challenge of data, right? It is all pervasive. So it touches upon everything. And so as a practitioner, you've got to be able to deal with these issues as they arise and help organizations navigate them. And there are lots of tensions. So you mentioned a few there, the tension between ensuring AML compliance, which requires you to actually go deep into an individual, research what they do, their background, beneficiary owners, lots of information that's required in that exercise, in that due diligence exercise, that can cause tension and conflict with data protection and privacy. And how do you strike that right balance between the two? And there was a belief within financial services that AML will always trump because the risk of getting that wrong was far greater than any fine that you could receive from a data protection authority. And then the data protection fines started to come and were rising. And so there was this recognition that actually we need to take both seriously. And there is a path and a way forward where actually both rights are recognized, and you don't need to infringe the fundamental rights of individuals to have a strong and a robust AML program in place. But you have to understand what the obligations are and to have those conversations and to have that accountability in terms of the decision making around those processes.
That's for sure. One thing I'm stunned at is the inherent conflict between AML, which basically, you see it in the US now, even relating to things like digital assets and the amount of information that's being sought after, all at the same time as you're hearing about SolarWinds compromising those very institutions which would centralize this information. It's a stunning irony. And there's an inherent tension that I don't think is going to be alleviated anytime soon. You can't have one without the other, and it's a delicate balancing act because you do start to infringe on developing countries, but there are a lot of countries in the world where financial privacy is very important because of totalitarian regimes and the like, and yet having that privacy can actually facilitate things where you don't have those protections. With that said, Schrems II. The U.S. has just not had a good time getting it right in the EU with privacy. We've been on, we've been off. We're constantly trying to find our way. But Schrems II, EU said, no, not good enough. It's not working. Want to talk a little bit about that and what it means for us in the U.S.?
Yeah, so this is a sort of a long history of frameworks that were found to not be fit for purpose, effectively.
Yep.
There was a safe harbor, remember that?
Yeah, I remember.
Which existed before the Privacy Shield.
Yeah, so I got schooled up on the safe harbor just to then have to worry about the Privacy Shield. Now I got to go back to the books again.
Exactly. So that was declared invalid. So there was a scramble to find a replacement for it. And that replacement was the Shield. And we felt, well, okay, this will facilitate transfers of data between the EU and the US. Incredibly important if you think of the value really associated with that transfer. So many tech companies that deliver services to the rest of the world based in the US that rely on data flowing freely between the various regions and the frameworks that facilitate that, one of which was the Privacy Shield. But there was a challenge to that. And effectively, what Schrems put forward was that the Shield did not offer the level of protection that was required under European law. So it was effectively an ineffective mechanism to protect the rights and freedoms of individuals. And initially, that challenge was raised with the Irish Supervisory Authority, and they referred it eventually to the European Court of Justice. And I think it's a very interesting decision in that what it does, it shifts the responsibility back to organizations and also to supervisory authorities to think about the data that they handle, to think about the risk that data processing presents to fundamental freedoms and rights of individuals, and to do their own assessment and risk mitigation around that processing. Now, that, some would argue, is a very onerous responsibility for organizations to carry. But the truth is, it exists anyway under law. Under the GDPR, you're required to do this. And I guess what Schrems does is just it throws that spotlight on the obligations that sit within organizations in any event. And yes, I think there has been a scramble to actually even understand the data that's being processed, because many organizations really didn't have a good handle on the information that they're processing and whether indeed that information is flowing to the US or other third countries that may not offer the same level of protection as individuals would have if their data remained within Europe. Interesting times, certainly.
Yeah, you're right in that the obligations really don't fundamentally change, although from a reporting perspective, from a diligence, from a contractual perspective, you have to deal with it differently yet again. So keep your privacy agreements flexible. And then, of course, here we are thinking about, oh, geez, the Schrems decision impact, and then Brexit comes along. And now we're going through the same thing again. I don't think that the UK is going to be kicked out of the Privacy Shield, but that's also being assessed, right?
Yeah, so Brexit, it's been very fraught right to the dying moments, but a deal has been struck, and I think it will take some months to unravel the devil that will be in the detail, for sure. But certainly in terms of data flows from the UK to Europe, we have a 6-month reprieve, and they will still be considered adequate for the next 6 months, certainly, whilst the European Commission decides on whether the UK is going to be afforded the status of an adequate country for the purposes of data flows. Certainly, whilst the UK was part of the membership of the European Economic Area and the EU, it was part of the 28 member states. Information could flow freely from the UK to Europe and vice versa. Now we enter this phase of the UK falling out of the European Union. It's effectively a third country. Organizations that have flows of data from Europe to the UK need to ensure that data is properly protected. And what we understand for at least the next 6 months, and thank goodness, because there's so much that we're having to deal with the pandemic and COVID and economic pain, really, that organizations are going through. Thank goodness that there is at least this 6-month period where we have a degree of assurance that transfers are safe. But essentially, the issue doesn't go away. We still are looking to see whether the UK is going to be afforded adequacy by the European Commission. We still need to think about the mechanisms and programs around data transfers, and then some practical considerations, because the UK will have its own version of the GDPR. So organizations that are operating within the UK or targeting individuals in the UK will have to think about that UK GDPR and compliance with it in much the same way as you would if you were running a global program. Would have to consider what your obligations are, for example, in Brazil under the LGPD, or in Singapore, or in China, or in India, in South Africa. You also have to add to that list the UK if you are targeting or operating within the UK.
And I guess that leads me to my next question, which is, so Google and Facebook, which are American companies, and they have their own GDPR compliance structures in the US. They had them in the UK, and they say, you know what? We're just going to migrate. This is too much for us. It's too confusing. We don't know what to do. Let's just move all that data back to the US. What do you think was behind those decisions? And does it represent something more?
Yeah, so it's a very interesting move. And I guess, and I don't have any more insight into the decision making than you, Eric, but just as an outsider, objective sort of reviewer of the situation, I guess they have a strategy around managing European data, which is that European data is going to be managed through Ireland. And actually, that's quite a common strategy, in particular for US tech companies. They effectively have their lead supervisory authority as the Irish supervisory authority, and their main sort of European centre, if you like, is Ireland. And there are all sorts of practical reasons why that would happen. Same language, common law, background and history. You can understand why that would make sense. And it's growing in terms of the attraction to locate your European operations in Ireland. And they may then have an approach to deal with rest of the world data and obligations from the US. Just very practically speaking, that's perhaps what sits behind that decision making. What I would say, though, as a data protection officer and looking at the landscape globally, is that there really ought not to be certainly a race to the bottom, because that's the fastest way to lose trust of your customers or your employees. And I just think the world has moved in a different direction when it comes to privacy and data protection. And any organization that's not moving in that direction of enhanced rights, recognizing how important this topic is to individuals, will lose the trust of individuals. So I don't for one second believe that it is a race to the bottom. I certainly hope not. And I know the two organizations that you've mentioned certainly invest a lot in privacy and data protection and holding themselves out as understanding and respecting those rights. Is it a race to dilution? I hope not to, because I think the world is moving in the direction of enhanced rights, and certainly individuals are very aware of their rights and wanting to exercise them. So it may just be a practical step in terms of managing global data from the US and managing European specific data from Ireland. But we'll see how that plays out. Essentially, GDPR has raised the bar, and many organizations operate to that standard globally, don't they? Because they feel, well, if we're meeting the GDPR standard, then we will, generally speaking, meet our obligations across multiple regions. We may have to make some tweaks locally to deal with localized requirements, but we're not going to find ourselves falling far short of the bar and requirements in different regions.
And even in the US, where we're on the other end of the Schrems decision, California is basically positioning itself where it probably could benefit from the Privacy Shield as its own jurisdiction for companies operating underneath the now CPRA, as well as the more recent one that California is going to have its own data protection authority. That's wow.
And it's always been at the forefront, California, in setting the standards on privacy. And yes, absolutely, seems to be doing things. And it's still very much a consumer focused element, which is slightly different from the fundamental human rights approach that the Europeans take to protection. And I think those local differences and nuances need to be understood and respected and observed. But yes, I think in terms of championing transparency and privacy rights, California is leading the way, but there are other states as well following. Washington's looking to introduce legislation. So I think this is, as I say, the direction of travel, and the US is no exception. There's still lots of talk about whether there might be a federal act in place. What would be your bet, Eric, on that?
Not 2021, but I actually think it will start to gather steam. I think this gets into the politics of it, but I think definitely with the Biden administration, definitely with, you see things like the SolarWinds just heightens the sense of that privacy is needed, even while we're pursuing more stringent AML controls, which we talked about. So I think it's something that gets underway. Something of that magnitude wouldn't move swiftly through in 2021, but I could definitely see it within the Biden administration. In fact, I will just go out on a limb and say I'm 95% it occurs within the next 4 years. And I think that's a safe prediction, because I don't know how you can look at what's going on and the way that California is positioning itself and the way that Washington, so many things in the United States is done on a state by state approach. But if you want to be, for example, I've talked to another guest, Felix Shipkovich, about money services businesses laws. If you want to do the money services business in the US, you have to apply, you have to register in 50 states. That is really expensive. And if you have data across multiple states, or you want to contemplate more of a national level approach to privacy, how do you do that? What are you going to do? Washington, California, you get your big grid out. The lawyers are making tons of money, but they're just exacting this rent from everybody for doing something that could be simplified. So I don't think there's a choice.
Yeah, having that certainty and having that sort of umbrella approach would just make a lot of sense. Fragmentation that currently exists and increased fragmentation.
And confusion. People get the wrong advice, or they can't get, the experts don't emerge. There's so many problems with doing it state by state and piecemeal approach. And particularly now that we've gotten the Schrems kick in the butt as a reminder that we need to get our act together on that. So now I want to talk about the other thing I have on my list, which is privacy by design. So we talk on this podcast, we do a lot talking about like machine learning and AI. And when we were talking prior to this podcast, we talked about how the dangers of bias, and there's practical aspects to bias in machine learning, meaning you get bad data, you get the wrong decisions, you violate people's privacy rights. And then there's policy aspects to it too, in that, are you favoring certain portions of the population? Is there a bias that you don't even detect? So I'm going to ask you about both of those, starting with the practical and shifting over to the policy. And again, you've been advising EU legislators, so it'd be very interesting to hear your thoughts on that.
Yeah, I think it goes back to who is doing the coding. Ultimately, what are the structures that we have in place? And it is a fact, isn't it, that certainly women are very underrepresented when it comes to design and coding and machine learning. So that's the first. And then when you start to think of minorities, the structures that we have in place are already not designed for diversity, and you're not bringing to the discussion and the product design diversity or privacy, because those are afterthoughts and they're not built in. So what you can have, as you say, is bad decisions, but multiplied and actually made at sort of the speed of light. And it's very difficult then to reverse that process, because you already have the biases built into the code. It's like, how do you reverse that? And we've seen some practical examples where, for example, there's facial recognition technology that had a bias against dark skin. And this was in the gaming context, but you can see in other contexts too, where perhaps the bias is to train the recognition technology on darkened skin because there hasn't been the built-in concerns around the impact to certain groups of society. And inevitably, the vulnerable groups are not at the table when the design is happening because they are disenfranchised. They don't even know about it. And so it becomes very challenging, and it's built in. That's the sort of practical implications of, and we've seen this in different contexts. Certain organizations even pulling back from sharing their technology with certain regimes and also with law enforcement because of the fear of the biases that have been built into the technology. There's a sort of recognition that, look, we need to take a step back and address this before we start to use these technologies, because they are very powerful, incredibly powerful. And I think it's almost raising the awareness. It's like the Black Lives Matter movement. You've got to be aware of the prejudice that exists and have done for centuries. And once you have that degree of awareness, you can start to think about, how do we reverse these? How do we break them down? But if you're operating in ignorance, you're just perpetuating. And I think what 2020 hopefully has taught us is that there's a lot we need to learn and we need to have the humility to accept that, really, because we can't start to make progress until we accept that there's a lot that we've achieved as a human race, for sure, but there's a lot that we absolutely need to learn too. And leading to your second part, we need to influence the policymakers around this too and raise their awareness.
For sure. When you think about machine learning, it is often very outcome specific, right? Why are we taking in all this data, running all these algorithms, collecting all this data? We have different outcomes we want to achieve. And those outcomes can become the oracle, so to speak, for other technologies that feed into it. So if you're focused on specific outcomes, but you don't understand sort of the micro forces or the policy implications or the places where your algorithm, it seems like it's minor, it doesn't necessarily change your outcome that you're looking for at the moment, but then you're building other things into those outcomes. And now you're institutionalizing these mistakes, these failures that may not become apparent initially, but down the road, all of a sudden somebody's like, whoa, hold it, that wasn't intended. But now you have an oracle that people have accepted as being the oracle, so to speak, and you're drawing data from that and you're making other determinations from it. And you could find yourself in a situation where you've institutionalized certain biases that nobody might have actually even affirmatively sat down and said, we're going to do this, but now they're built into the system.
Absolutely. Absolutely. And it's that systemic and institutionalized bias. It's just the most difficult to eradicate because, as you say, you almost sleepwalk into it. And so it's for us to say, hey, look, we have evidence of how this can just have a devastating impact over time. Let's address it now, because actually it's accelerated when it comes to big data.
Yeah, it would be ironic if in the wake of Black Lives Matter and everything we've gone through as a society, if looking at the more physical, the real world examples and missing what's occurring at the machine learning and AI and the large systems level. And listen, privacy by design, there's biases throughout, meaning it's something that there's the policy considerations, there's race, there's gender, and then there's just getting it wrong too. This makes sense in the long run. We need to create models that are actually reflective and that reflect policy decisions as well. And that's how we're going to get better systems. And that's how we're not going to have major breaks later on that people are scratching their head and trying to figure out how to undo it.
Absolutely. And this is what we absolutely advocate for as a data protection office, because we are able to bring that sort of objective view to the boardroom. And we don't have any ties, with the organization, except for wanting them to do the right thing, which we think will add value to their brand. Really, that's our interest. So we can have that objective voice and we can hold them to account in a really good way and help them build that sort of privacy by design into their processes and their products. And ultimately, doing it in a way that is fitting with their organizational culture. Because that's the thing about privacy by design. Effectively, it has to come from within and it has to fit within the organizational culture. And so that's something that really excites me because it's not this sort of nebulous concept. It's very practical. And a good friend of mine and fellow practitioner, she said, it's almost you're building a pizza. So you give the organization all the ingredients and then they go ahead and they build that pizza that's right for them. Now, they may place the mushrooms and the sweet corn and the pepperoni in different places, but that's okay. It's just so long as it's done and it's understood by the organization. And that's what privacy by design is about. It's about bringing that concept to life. And much like we discussed earlier, you have to have the buy-in at the top level in order to achieve that change and to also champion all the good things that are being done on the privacy front within an organization, because that's also part of how you build privacy by design. You recognize when you're doing it well and you reward that, you amplify that, you champion the good things that are happening on privacy.
So I'm going to throw you a bit of a curveball. So we talked about the prevention, but what about detection?
Yeah, and actually the internal detection, that's actually very challenging because often what you find is where an organization is investing in a robust program, they will find more issues. It's almost in a way, it's easier to look away and not do the work, because you're going to come across issues. But actually, that's a good thing because it's any sort of unresolved problem. It's just going to grow and it's going to become a bigger problem. So the sooner you tackle it, as challenging as it might be at the time of doing it, the sooner you tackle it, the better. And that's where having an infrastructure within your organization that allows you to have the sort of the foot soldiers on the ground that firstly have an understanding of data protection, privacy, what the requirements are, operating within the different functions of your organization and being able to detect the issues as they arise and escalate them and feed them to those that have responsibility for decision making. And it may require sometimes a degree of risk taking. That's fine. It's just a question of doing so with awareness, mindful risk taking, as opposed to blind risk taking. So if you have that awareness, you have the issues raised to you, you say, this is a level of risk that we are prepared to accept. And senior individuals within the organization sign that off, fine. But you might find actually there's some risk that you're simply not prepared to accept as an organization, as a business. And better those risks are raised and you're aware of them and you are able to do something about them than for them to just continue to exist undetected.
Yeah, I wonder, like in cybersecurity, we have bug bounties, right? To identify security bugs in systems and programs. I wonder if at some point in the future we start to do privacy bug bounties, right? We're testing out various outcomes and somebody gets a bounty for figuring out, particularly as you start to get to some of the more impactful consumer base. Obviously, you couldn't do it real consumer data, but that would be intriguing.
Absolutely. And actually, look, you've got an opportunity to really listen to your internal stakeholders who can actually draw your attention to a lot of significant issues as a senior leadership team, as a board, really paying attention to what's coming up and bubbling up from within the organization. And actually, if you're a consumer-facing business, often your call centers and individuals that interface with consumers can be a really useful source of information to actually understand how your services are landing. So are you really listening? Are you gathering that information? Because it could be incredibly helpful to you as an organization.
That's a great point. Let me ask you a question now, shifting gears a little bit. So how might GDPR and all the privacy regulations that we're putting into place create additional exposures of consumer information?
I think, look, the GDPR has definitely raised awareness across the globe on the importance of privacy and actually being transparent as an organization about what you are doing with individuals' data. In terms of increased risk to information, I think some of the frustrations that have been felt and certainly articulated to me is where there is a fear of acting and actually sharing information. And sometimes what's raised is, data protection or GDPR concerns, this can't be done. And sometimes it's been argued that might create risk to individuals because it may prevent them from accessing certain services, and in particular, when it comes to public sector data sharing or lack of, could result in harm to vulnerable individuals. So that's where sometimes there are concerns that actually it's not the GDPR itself, it's typically a lack of understanding of the law and a fear of acting in a way that may be perceived as a breach of the GDPR, regardless of whether it is an actual breach or not. And that's where you really do have to have qualified advisors that understand the nature of the law, understand the guidance that's issued by the supervisory authorities, and are able to advise. And I do sympathize in particular with small businesses where they don't have that expertise available to them, in particular in-house. And that can cause frustration. But for those that have got good advice, you have good advisors, and you're able to put the guardrails in place, it gives you this sort of ability to operate freely and to innovate as organizations need to do, or indeed to share data for public interest benefits and others and to prevent harm. So it's understanding and being able to interpret and being able to advise. And the flip side is where you don't have that understanding or you have bad advice, which occasionally does happen sometimes, it can result in harms and an inability to access services or also stifle innovation.
Great. So I'm going to ask you, so GDPR creates all kinds of rights for the residents, right? They can bring suits against the processors, the controllers, the data protection authorities. But has that been executed on? Are there obstacles to that? Do you have a point of view on that?
Yeah, it's interesting because there was a perception that there would be an explosion of class actions with the GDPR and that Europe was going to follow in this sort of American style approach. But I think that there are local and cultural differences that need to be understood. Generally speaking, there hasn't been that explosion. And that's because actually to bring a class action, the number of barriers in certain European jurisdictions, you have to opt in to be a participant within a class action, as opposed to the US style where you effectively can begin a class action where a number of individuals are impacted and they have the right to opt out. So that in itself is a very different way of doing things and can act as a barrier. Also, under the GDPR, not-for-profit organizations are able to bring class actions on behalf of individuals. But how do the rules around what qualifies you as a not-for-profit organization? And if you are raising funds to bring an action, you may be disqualified. And litigation is very expensive. In terms of individuals or organizations being galvanized to bring an action, often it's said the beneficiaries are not necessarily the individuals, because by the time an action has been funded, the lawyers have been paid, the representative organization has taken out its costs, individuals are actually ultimately left with very little. So there's all sorts of practical, financial challenges, legal, procedural challenges around bringing class actions. That said, there have been a number of cases, certainly in the UK, which suggest that actually the courts are more open and certainly facilitate the idea of class actions being taken. And Morrison's is a good case, which was related to an employee that effectively disclosed large volumes of personal data of colleagues in almost a sort of as a way of attacking Morrison's, the organization. And the courts did find, actually, that in that situation, that the employees could bring a class action against Morrison's. Ultimately, the individual who disclosed that data was found criminally liable. So it's not a good idea for employees to act in that way. And ultimately, also, Morrison's were found not to be liable, vicariously liable of the actions of their employee. But that said, it was a landmark case in that it did facilitate the bringing of a class action by an employee base. So I think ultimately it is possible. And as individuals become increasingly aware of their rights and exercise to bring claims, it's very much something that we could see a rise of. And we talked about how successful Max Schrems has been in raising issues of privacy failures. And you can see how effective those sorts of organizations and bodies can be in their action.
Max Schrems was, you would classify him as more of an activist as opposed to somebody seeking maybe a monetary reward or damages for the privacy failure.
Indeed. But there are definitely a rise in claims being brought against organizations. And obviously, Max Schrems has this sort of headline platform in terms of the impact that he's had. But many organizations face claims from employees, claims from customers for mishandling their information. And actually, it can be incredibly expensive and disruptive to an organization, in particular, if they don't have the procedures in place to deal with those claims. One of the rights under the GDPR is this right of access, subject access rights that individuals can bring against organizations. And actually, if organizations aren't able to meet those requests, it can prove to be incredibly disruptive, and individuals can claim for compensation. And it's a question of, what do you do? Do you face the risk of an individual going to supervisory authority and exposing your lack of compliance? Or do you settle? Do you offer compensation? So those sorts of issues can be incredibly challenging. And that's where I would always advocate for a proactive program build as opposed to reactive dealing with the risk of individuals bringing claims or issuing subject access rights, or indeed risk of class actions.
And it's interesting if you think about the US getting back to the federal law, if you have a number of jurisdictions that start to recognize these rights, and you have actions being brought in jurisdictions that don't have these legal frameworks, but how can it not bleed? Basically, the judge going to rule, say, you don't have that right. And whereas right is increasingly being recognized. And I think it's hard to have, once you start to get a critical mass of enough states, it makes it very difficult not to, because it's almost like you're exposing the companies within those jurisdictions that don't have that legal framework to actually more risk long term, because they're not going to catch up.
Absolutely. And you're at such a disadvantage if you don't have that framework in place, ultimately, especially where you're operating globally. And as you say, the standards are rising. So you don't want to have that weak link, really, which will leave you very exposed, whether it's at a sort of state level in the US or a jurisdictional level globally.
So in 2021, you take out your Heward Mills crystal ball. What do you see in privacy? What are the big changes?
So I think definitely a trend of increased awareness, engagement by activists, individuals who are very exercised about their rights. I definitely see organizations that are progressive, developing privacy by design frameworks, implementing them, championing them, recognizing that as the only way to build trust. I definitely see legislators and supervisory authorities and supranational organizations such as the Commission looking to develop ethical as well as legal requirements around data, because there's a sort of understanding that actually you can get some very clever lawyers to help you navigate around the laws, but actually just because you could do something with data doesn't mean that you should be doing something with that data that would potentially not be within the legitimate expectation of individuals. And how can you be assured as an organization that you're acting within legal as well as ethical compliance and increased engagement with stakeholders and also vulnerable groups or individuals who represent vulnerable groups, to ensure that not only are you baking in privacy by design, but also diversity by design, which is a big passion of mine.
And it's funny, I had David Harris from Manitou has a platform that's basically for consumers to access various information about how a company is using their information, consent, all that stuff, largely playing into the California set of regulations. But what he told me is that the people who are experiencing the most amount of interest in his platform aren't necessarily from California. They're companies who want to get ahead of it. They want to implement this now. They don't want to wait till some point in the future. They want to answer their shareholders. They want to answer their employees. They want to answer their customers. They want to say, this is how we're treating this information. We have a process in place. And so what was really intriguing to me in talking to him was it isn't people running to him and saying, oh my God, California, I have to comply with California. It's companies saying, we want to implement this because it's a sound company practice. We're a multinational company. We don't want to be caught trying to back end this. We want to get ahead of it and we want to implement it. And we don't want a massive disruption to our systems as we're trying to get into place in response to whatever kind of regulatory or legal threat that we may face. I thought that ties right into what you're saying, which is this, it's not just about being forced to do this. It's about saying, listen, this is where we're going. If we have a multinational company, who are we kidding? This is where the world's going.
It's not about we're going to meet the expectations. No, you want to exceed expectations. That's what you champion, right? And so those progressive organizations will want to exceed expectations on privacy because it's the right thing to do. Respecting individuals' personal information, upholding data dignity, that's the right thing to do. So you want to exceed expectations on that.
Yeah, and it's not that much harder to do once you start. In the financial services space, being over-compliant, there's tons of laws. If you're over-compliant, you're shelling out big bucks. In the privacy space, to do more than what the statute absolutely requires you to do, once you're down that path, it's not that much harder. Dyann, where can people find out more about you, Heward Mills, find out what you're saying, what you're writing, when you're speaking, all that good stuff?
Oh, yeah. So I'm on LinkedIn. There are not many, if any, other Dyann Heward Mills. So over Dyann, you'll definitely find me there under Heward Mills and on the website, www.hewardmills.com. So when we post a lot of stuff as well, we post some blogs, and I'm always really keen to hear from other practitioners, other individuals, organizations. Share your thoughts on data dignity, on data ethics, on data protection, compliance and privacy, and the way in which the world is going on this topic. Thank you so much for inviting us. It's gone so quickly. I really enjoyed chatting with you. And so thanks so much for the opportunity.
No, it was great to have you on the show. Thanks so much, Dyann.